I'm going to read the first paragraph, and then we'll have someone read the second and third, and then we're going to do the questions on our own. So I'll go ahead and start reading this one. So the following passage was adapted from a law journal article published in 1998. All right. Industries that use biotech are convinced that intellectual property protection should be allowable for discoveries that stem from research and have commercial potential. Okay, so industries that use biotech think that intellectual property protection should be allowable. So what is intellectual property protection? I had to think about this for a second.
IP, that's what protects, like when you invent something. So it's all for people who are doing any kind of inventions, and it's protecting, it could be
the patent, yes.
Right, the patents.
There should be allowable for discoveries that stem from research and have commercial potential. So essentially, like, I think that there should be some type of protection for my research. All right. Biotech researchers and academic institutions increasingly share this view because of their reliance on research funding that is in part conditional on the patentability of their results. Okay, so biotech researchers and academic also agree with this because of their need for funding. However, questions about the extent to which biotech patenting is hindering basic research have recently come to the forefront. And the patenting and commercialization of biotech inventions are now the focus of increased scrutiny by scientists and policymakers. Whoa, that's like a 5-line sentence. But we're saying that people are now questioning, is this patent hurting us? And these patents and the ability to like commercialize these inventions are the focus of increased scrutiny by scientists and policymakers. So scientists and policymakers are scrutinizing these people for these patents. My first question after reading this is why? Like, what is bad about patenting this? I'm questioning it. I'm being curious. Why? And this is a paragraph that it's short and you think it would be easy to read, but I spent about a minute and 20 seconds reading this paragraph the first time, because if I didn't understand what some of these words were or what they were trying to break it into, I would struggle with the rest of this. But I actually read the rest of this passage pretty quickly since I spent so long on the first paragraph. Who would like to read the second paragraph? We'll have you do half of it. Who wants to read? Cora, do you want to read until
Sure. Read to where?
I'll make a line, but you just start reading.
Okay. So the perceived threat to basic research relates to restrictions on access to research materials, such as genetic sequences, cell lines, and genetically altered animals. These restrictions are seen as arising either from enforcement of a patent right or through operation of a contractual agreement. Some researchers—
Stop there. Explain this to us so far. What is happening?
Okay. So this is going back to the why, this perceived threat of basic research relates to restrictions. So when you put patents out there, it's restricting, it's going to restrict other upcoming people that are trying to also do inventions as well. That's what I get out of it.
No, perfect. Keep going.
And then it gives you examples that, you know, the genetic sequence, those are just examples of all this up and coming technology or what these other entrepreneurs are doing. And then it talks about these restrictions are seen as arising either from enforcement of a patent. So enforcement of a patent could literally mean like you're up and coming entrepreneur and then you're going to your patent attorney and they find this other patent that's out there and they're like, no, guess what, you can't do it. Or you're getting sued. That's what I got out from that enforcement of the patent. So enforcement of the patent right or through operation of contractual agreement. Again, that's just going through, you know, understanding that when you're up and coming, there's so much process that goes on between you and your patent.
The people that you get patents are holding us back, right? That's what I got from this. Patents are holding us back or holding people from access. Excellent.
And I mean, and I can see where they're going with this. They're like how these patents are, you know, if you patent everything, entrepreneurs that are constantly thinking of new and improved things are going to be held down.
Absolutely. I was just thinking from like a medical perspective. But anyways, all right, continue.
Okay. Some researchers fear that patenting biological materials will result in the patent holders attempting or threatening to adjoin further research through a legal action for patent infringement. And this right here goes back to that thought process of being sued. If you are or going through that whole process of being sued, that fear of like, hey, I want to, like you said, biological materials is medical. So you're coming up with maybe it's a cure for cancer or something like that. And your cure that you're trying to build is somebody else's very similar patent that they've already got out there. And that they might sue you for it.
Awesome. Katie, can you read the second half of the paragraph?
Sure. Okay. In other instances, a patent holder or the owner of biological materials may refuse to make such materials available to scientists conducting basic research unless a costly materials transfer agreement or license agreement is undertaken. So, another potential issue with patents is that the owner of the patent it will disrupt the power dynamic. So if someone has a patent for these materials, they could just refuse to let other people use it, even if they're using it for research, unless they use that to get a ton of money or other things. For example, the holder of a patent on unique biological materials may want to receive a benefit or compensation for the costs invested in the creation of the material. So if they own it, they're going to want a percentage of the research of the product. Academic researchers who oppose biotechnology patents fear that corporate patent holders will charge prohibitively high fees for the right to conduct basic research involving the use of patented materials. So people opposing it are afraid that patent holders are going to monopolize these materials, and it's going to make it harder and more expensive for people just to conduct basic research because of these patents.
Fabulous.
Thanks.
And then Gina, can you do the first half of this paragraph? And Abby, will you do the second half when she?
Gina's muted.
Oh, never mind. Oh,
Okay.
Are you good now? Okay.
Yeah, I'm good now, except for I lost where you were.
Oh, we're at the top again. I just put it on different slides.
Okay. So while it is true that communal tradition of freely sharing research material has shifted to a market model, it also undoubtedly true that even in the early days of biotechnology, some researchers took measures to prevent competitors from gaining access to materials they had created. So if I can understand this correctly, is that even though they've changed the way in which they share material based upon communal traditions versus a market model, they're in the old way, they could still prevent competitors from gaining access to the material just as they can now. Did I miss something there?
Doing great.
Okay. Scientists who resist the idea of patenting biotechnology seem to be confusing patent rights with control of access to biological material. They mistakenly assume that granting a patent implies granting the right to deny access. So they just say that they're confusing the difference between patenting something and then not allowing people to have access to it in order to use for other types of advancement.
Excellent.
In reality, whether a patent could or would be enforced against a researcher, particularly one conducting basic and non-commercial research, is questionable. So it's like creating a more correct assumption about what a patent does. And it's saying that the idea that like someone could deny access is questionable. First, patent litigation is an expensive endeavor and one usually initiated only to protect the market position occupied by the patent holder or an exclusive patent licensee. So it's giving one reason why the assumption is questionable and likely mistaken. And that reason is because it's really expensive. Second, there has been tradition among judges deciding patent cases to respect a completely non-commercial research exception to patent infringement. So it's giving a second reason. And that's like there's a tradition amongst judges in making these decisions within litigation that doesn't always favor the patent holder. Moreover, it is likely that patents will actually spur rather than hinder basic research because patents provide scientists with a compelling incentive to innovate. So it's actually saying that rather than the idea that patents like inhibit research, it actually might, incite more research. Researchers know that patents bring economic rewards as well as the degree of licensing control over the use of their discoveries. And the reason it might incite research is because they're economic rewards.
Awesome. All right, so we're running a little bit behind on time. So what we're gonna do is I'm gonna break you into two groups. I'm gonna put the dinosaurs in a group and the young ones in the group. And we're gonna answer these questions. You're gonna have 6 minutes to work together and we're gonna come back and talk about them, okay?
Okay.
Little competition to end our.
Thanks, Cora, for labeling us, by the way. Can't we be called gems or,
Oh, I know. It's like, now I'm like, it's stuck. Maybe
gonna
next
make me go back and buy some beauty cream to make sure that my skin isn't like chapping like a dinosaur.
Chapping like a dinosaur. Okay, then how do I get to the breakout rooms? Oh, here we go. Okay. Jasmine, Katie. I just need to add. So you're gonna go to 2. Red's gonna go to 2. Jaylene's gonna go to 1. And Katie 1. Okay, are you able to go to your rooms now?
Nothing popped up.
Nothing
Yeah.
popped up.
Oh yeah, if you click on join breakout room down at the bottom, the little window will pop up, Cora.
Okay, got it.
Awesome.
We're in room 2.
Bye.
I don't see it.
I will add you. Hey, don't click that one. Don't click that one.
Okay.
Don't click that because I have to move you. There. Oh no, not that one either. Hang on. 2. Do you see it now?
Where is it?
Do you see it at the bottom right, maybe?
I've got 3 screens here and I don't see it popping up at all.
Okay, go to do you have like the Zoom up large?
Oh, let's see, Zoom.
Do you have me minimized? If so, make me large again.
The camera picture or what?
Yeah, see it at the bottom right, like wherever your toolbox is or like your tasks.
Okay, just 1 second ago. I had it earlier. I mean, when we did it earlier in the breakout room, this time it didn't pop up. Oh, there it goes. Wait, let's see. Oh, that just says invite.
Yeah, hit accept.
Breakout rooms. Okay.
Oh,
I wanted to show you guys my Ardella's Halloween costume.
look it. Which one is she gonna wear?
Well, we did them for different events. This
I
one,
like Lady Liberty.
we did that. Yeah, like, that one's funny because like her Instagram is like leadership quotes. You should follow her on Instagram, Della the Doodle. But we were, I was a spider and she was a pig, and we did Charlotte's Web for a kids reading that we did at the library.
Oh my god.
Oh yeah, she's cute. She did not. We had to practice though. This picture's from practicing, so I had to put it on her head for like 10 minutes every day for like a month to get her to keep it, like not swat at it.
That's so cute.
She looks so mad. She hates me sometimes. Here, I'll show you guys her. She's like, Mom, it's Saturday. We're supposed to be out hanging out at the park. Yeah. Anyways, okay, so both groups got all of them correct. So congratulations. But the young group is definitely getting the $5 off because they finished like 10 minutes beforehand.
Oh my gosh.
Oh, we named ourselves the Feed
The
Eye.
feed eye.
Why? So how did I get moved to the
Yeah.
other group? I just want to
Jasmine,
know.
poor Jasmine got picked up in the old group.
I know.
But congratulations. But I think the ones that we need to go over are 7, 12, and 13. Does everybody agree with those three numbers?
Yes.
All right, what was the main point of the passage? All right, so Katie, what was your prediction here?
So I predicted that it would be something along the lines of, while there is debate about whether or not biotechnology patents should be used, overall, we believe, or they should, or at least to the very least, like
There's a place for them somewhere.
yeah, like they should be there. And so I just felt D was the one that best aligned with that.
Yes. All right. So let's look at A. By commercializing the research enterprise, biotech patents threaten the progress of basic research in the biosciences. This is definitely true, but it's, too narrow. Because is our author, does they write this just to tell us about the threat that biotech has? Or is it to express like, hey, I hear you and I hear these concerns, but we also need to see why we have them in the first place.
Mm-hmm.
And so I love Abby, right?
Yes.
Abby.
Yeah.
I love her comment that she made in the last passage of every passage should at least support this a little bit. And I think I did that on this one to check it. And I was like, ooh, A, every passage does not support A.
Yeah.
Or every paragraph. Are we good on this one? All right. Cora, can you read number 12?
All right. The passage provides the strongest support for inferring which one of the following. And Jasmine did a really good thing. She was like, she heard that anytime you want to infer, I can't say that word, sorry. Do it as a must be true. So
yes, because what does infer mean on the LSAT?
Yeah.
What does infer mean on the LSAT?
Most strongly supported.
No, conclude.
Include.
I grew up at a time, like when we grew up or in school, I feel like we learned that an inference is an educated guess. On the LSAT, it is not an educated guess. It's like beyond educated. It's like valid. It's a valid claim.
Yep.
Yeah.
And so for these ones, do we want I love that we said must be true. Do we want a strong or mild answer?
A mild.
Mild, yes. All right. So you can go ahead and walk us through this, Cora.
Okay, so going through the answers, policy makers are no less likely than academic researchers to favor new restrictions on biotechnology patients. I mean, that to me was an automatic, no less likely. I mean, it was a automatic no. I did not like it. B, most biotechnology, right there, that word most, was a big red flashing light. Holders believe that the pursuit of basic research in academic institution threatens, another big strong word, their market position. So that was a no because of it's too strong. C, biotechnology researchers who work in academic institutions and oppose biotechnology patents are generally unable to obtain funding for their work. to me, this right here, I mean, at nowhere does it say generally unable to obtain funding.
Yeah, like
So,
more often than not. Are they more often than not
Yeah.
unable to obtain funding for their work? We don't know.
right. So I'm going to skip the correct answer and go to
Huh?
E. E, rapid commercialization in the field of biotechnology has led to a dearth of highly educated biologists willing to teach an academic institution. This one just made me laugh. And I'm like, where does it talk about this?
Rapid
It was,
commercialization. Yeah.
yeah. And then D, suing for patent infringement is not the only way in which patent holders can assert legal control over the use of their patented materials. And we went back to knowing they actually talked about 2 different ways. So we knew that it wasn't the only way. So that was we knew that was true.
And I love how, okay, so it has only in it, but this is actually a very weak answer because it's saying there's at least one other way.
Yeah.
It's not saying there's a lot of other ways. They're saying at least one. So that's very mild and not hard to prove. It doesn't take much for that to be correct. Excellent. All right. And then Evie, do you want to do number 12?
Yeah. I mean,
13.
Or 13?
13?
Yeah.
Okay.
Yes, 13.
Yes. So suppose a university researcher wants to conduct basic non-commercial research involving cell lines that are patented by a for-profit biotech corp. The author would be most likely to make which one of the following predictions. So A, the researcher will probably be unable to use the cell lines because the corporation holding the patent will demand a prohibitively high.
Sorry, 1 second, Evie, before you do that. Sorry. So I'm going to ask you this. So suppose a university researcher wants to conduct basic non-commercial research involving cell lines patented by a for-profit biotech corporation. What the author would be most likely to make which of the following predictions about their researcher's prospects? What did you loosely predict here?
So we looked at I looked at the third paragraph, and that if the patent already exists but they still went ahead and did the research, and they were like sued or something, they probably, the litigation would be in their favor, or, like they also could be fined, or like different things like that. Anything that was supported by that last paragraph.
All right, now go ahead and mark the answer.
So A, the researcher will probably be unable to use the cell lines because the corporation holding the patent will demand a high payment for their use. I held on to this one.
I agree.
Yeah.
I left it open.
Yeah. B, the corporation holding the patent will probably successfully sue the researcher for patent infringement if she conducts the research without permission. I eliminated this one because of the second reason that's in the third paragraph, that judges usually favor non-commercial research. So like a university researcher. C, the university that employs the researcher will likely prohibit the research. I eliminated this one altogether because it doesn't talk about the university prohibiting the research. The researcher has a good chance of not being held liable. So I like this one again because of that second reason with the judge favoring them. And so I left that one open as well. And then E, the corporation will probably offer to fund the research if granted. And this one also eliminated because it says nothing about the corporation who has the patent funding the research by somebody.
Yeah, like, oh yeah, you can take our patent, we'll give you money.
Yeah, we'll give you money to do it. Yeah, that doesn't make sense. I went with D because it was directly supported by the passage, and also the good chance. I felt like that made it milder than A, where it says completely unable to use. So I went with D.
Yeah, and A says will demand a prohibitively high payment for their use. That might happen, but we don't know it for sure will happen.
Yeah.
Which is why I eliminated A. I narrowed it down to A and D as well. And I said, D, must be true questions. I sometimes negate them. And I'm like, what if I said the researcher does not have a good chance of being held reliable? Or the researcher has a good chance of being held reliable for patent infringement if she could, and that completely goes against the second point in the paragraph that you mentioned, where it would contradict. Awesome. All right. Does anybody have any other questions on these? This is a big morning. Does anybody feel like they learned something?
Yes.
Yes, I definitely did.
Perfect. Let me set this.